Ready?
Yeah, I feel like I'm downtown.
Do you want to come to the middle or can we just bring the
Why don't you come sit up?
podium over here? I just figured it might be better.
You know what, let me go from up there, I think.
Yeah.
Okay.
Just do it.
All right, so we're going to call this special meeting, the orientation, to order at 6 p.m. We do have a quorum of 5 members present. Items for discussion will be the board orientation, facilitated by Floyd Dugas from Bertram and Moses. And at this point, I will turn the floor over to him.
Thank you. So what I hope to accomplish tonight this evening over about the next hour is to give you an overview of the legal framework that we work in, that you guys operate in. And not that I want to turn you into lawyers, but I think it's helpful to sort of understand why you do some of the things you do. And hopefully this will assist you with that. I've got an outline I've provided to everyone. I'm going to follow more or less. However, if you have a question as we go along, please don't hesitate to raise it. If I address it later on, I'll come back. I'll just say I'll come back to it, but I don't have a problem with stopping and addressing any questions you may have. So when I do these presentations, you want to start where it all starts, right? So where do public schools in Connecticut, where does this whole thing start from? And believe it or not, it starts from the state constitution, okay? Article 8, Section 1 of our Connecticut Constitution guarantees the children of this state a free public education. And so that's in the Constitution. It says that the state guarantees it. So how is it that you guys are responsible for it? And the short answer is that the state, as it likes to do, has delegated that responsibility. And they've delegated to you as local boards of education, as well as to regional boards of education. So that's where it all sort of starts. And that kind of begs the question, are you an agent of the state, or are you an agent of the town of Stratford? And the answer is really that you're an agent of the state of Connecticut, responsible for carrying out the laws. Now, you have to, of course, comply, also at the same time, comply with the charter of the town. So there's certain obligations that you have, particularly around budgets and things of that nature, but for the most part, you are an agent of the state carrying out the guarantee in the state constitution to give children a free public education. Now, I could literally fill this stage with the legislation that governs what you do. We have, of course, many state statutes. We have many state regulations. We have federal regulations and statutes, and they're just voluminous. But what I've done here is tried to identify just some of the key pieces, again, just to give you a sense of why do you do what you do, okay? And what's your authority, and what are the limits of it. So the first statute that I talk about here, remember I said that the state has delegated the responsibility to you, and that's basically done through Connecticut General Statutes 10-220, okay? And it's a pretty long statute. It's got a lot of verbiage, but it really does a couple of things. Number one, it delegates to you responsibility to maintain, quote, good public and secondary schools, okay? And the second thing it does is that says you're responsible for implementing the educational interests of the state. Good luck finding a definition of what that means. It means a lot of things to different people, but There will be times where somebody could file a complaint with the state of Connecticut and say you're not really following your obligation to implement the educational interests of the state, and that's where that could come into play. The statute then goes on to list a number of other responsibilities that you have, including providing books, providing a safe school setting, and I won't go through all of those, except importantly, you don't have to sit here and go home and say, oh my God, how am I going to ensure these good public and secondary schools, because that's primarily accomplished when you adopt your budget. Okay? The second key statute is Connecticut General Statutes 10-21. And what that says, well, what that does is it gives you broad authority to develop policies for the management and discipline of the schools. And it goes on to say a number of topics, including homework and attendance and promotion, and there are a lot of others. There are some mandatory statutes, there are some that aren't mandatory, but really that is the primary function of the board. If you were to go to national conferences like the National School Board, or even talking to CABE, in an ideal world, they would tell you that's all you do, is set policy. Now in Connecticut, there are other statutes that give you specific responsibilities, which I'm going to touch on, but that's really the primary responsibility. The other key one is 10-222. That talks about the budget process. You guys are probably knee-deep in that already. And, you know, importantly, once the budget is, you're allocated, you're given an allocation by the town, it's up to you to decide how to spend it. The town can't put conditions on that. They can't say, well, you ought to have, you know, only X amount of teachers. We think you should put money aside for this capital project. They really can't do that. It's up to you how you decide to spend it. Now, importantly, the last bullet point you'll see there is that the statute says expenditures shall not exceed the appropriations, and members may be liable if they do so. So that at the end of the year, you want to make sure there is not a deficit, okay? And you guys have, you know, good responsible, you know, management and procedures to make sure that doesn't happen, and just so that you're not worried and running home and transferring your house to your spouse or something. In the 37 years I've been doing this, there have only been 2 districts that have come close to being held accountable where there's been a deficit, and deficits happen from time to time. One is where there was outright theft, I believe it was up in Winsted, and another was where there was just a mess in Amity over asbestos about 25 years ago. But so I don't want to say, you know, it could never happen. It's extremely unlikely, but just be aware it's in your personal interest to make sure at the end of the year there's no negative number when everything balances out. Okay? Another statute that I think is important is 10-240, and what 10-240 and 241 say is the following thing. Number one, the town, as I'm sure you know, owns all the buildings. Town owns this building. Town owns every building that you use, but you have the exclusive authority to use that building as long as it's being used for school purposes, and school purposes includes the central office and what goes on there. You can decide how the building gets used. In most communities, I'm sure this is one, you know, you're a good citizen and you allow Park and Rec to use, you know, the gyms for basketball and community groups and so on and so forth, but that's totally up to you whether you choose to allow that. If and when you're ever done with a building, there's a process where you turn it back over to the town. You'd have to have a vote to do that, but until that's happened, you are responsible for the buildings. There's a term that's called, you'll hear the term school district a lot, And what I'll tell you is it's misused all the time, sometimes even by lawyers. Technically, the term school district is the town of Stratford, the geographical town of Stratford. And only the town has the ability to do certain things like raise taxes. You may read sometimes about some school in Oklahoma or somewhere where they, raise their taxes or something. And, that's different law, different legislation. In Connecticut, only the town has the authority to tax people, and importantly, only the town has the ability to borrow money. So, for example, if you were entering into, let's say, some type of lease arrangement for computers or photocopiers or something, technically that's the town's authority, so you have to get the town to bless that. Okay? In the past, a lot of school districts, using the term incorrectly there, but public school systems have entered into leases and things of that nature, multi-year leases, which are basically financing arrangements. And they haven't gotten approval of the town, and we're learning more and more that the town needs to bless those sorts of arrangements. And then another source of law, if you will, are your bylaws. Now, bylaws are not statutes, they're not ordinances or charter provisions, so that nobody's bound by them except for you guys. They are think of it as your own internal laws about how you conduct yourself in various things, and so that's another important layer that we need to be aware of and look at, and if you haven't, I commend you to look at that. I understand from the chairman we may be looking at revising those at some point in the future, but you should certainly be aware of those. And then probably the only other major important law is the Connecticut Freedom of Information Act. And I'm going to get into a little bit more on that a little bit later on. Okay? So before I transition, any questions on any of that? Yeah.
So you had talked about only the town has the authority to borrow to lease. If we lease, you said, like, say, equipment, whether it's repair work type equipment, or if we haven't to date gotten the blessing of the town, would we have to go back and get that blessing, or how retroactively, how would that work?
We should probably talk about that offline.
Okay. Very good.
I certainly would recommend that be the practice going forward.
Okay. And so moving forward, if we do come to a spot where we choose to lease, or the procedure would be to send it to the town?
Yeah, we would decide and talk about whether it would actually be the town that entered into the agreement,
Okay.
or if it's the board and it's just approved and blessed by the town.
Okay.
Either one tends to work.
Okay.
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 Okay, so Mike, can you pass
Yeah,
down
Lisa,
your packet?
get Lisa's. Or do you have them here?
Oh, is there one here?
Yeah, because this is Lisa's seat.
Just take is there one in front of you?
Yeah, that's it, right there.
Okay, so next section I have is individual board members and authority. And so the first thing, there's a statute that says in order to be a member of a Board of Education, this Board of Education, you have to be at least 18 years of age, and you have to be a resident of the town. Importantly, you are prohibited from being employed by the board in any capacity, coach, referee even. Now, occasionally a question will come up about volunteers, and first of all, I don't think that's a great idea for a board member to be involved at that level, but if you are, if it's an activity where you're replacing an employee, or an employee might otherwise be doing it, we could get into problems with the wage and hour laws, because you're required to pay people. If it is a legitimate, pure volunteer type of activity, in other words, employees don't typically do that type of duty, then that's an exception. But if that were to come up, we'd have to take a look at it again. Not the greatest idea to sort of cross that line if you're on the board. In the back, I'll touch a little bit more on this, but in addition to in your bylaws having some statements about code of conflicts of interest, code of ethics, code of conduct, Stratford, there's a statute that allows a town to adopt an ethics ordinance. Stratford has done that. Some of you may be aware of that. It's a pretty extensive document. If you're interested, I could forward you a copy, but it has a number of prohibitions in there. Generally speaking, the types of things that we see there are you can't, you or a business you're involved in can't do business with the board. Certainly not without letting everybody know about it. And you can't reap some sort of personal benefit from doing so. So if you're using my example of, copiers, if you sell copiers and you make a contract and you get, you're getting your commission or whatever it is, that would be a violation of the code of ethics. You can't use your position on the board to get a personal benefit or favor. It's things of that nature, so I encourage you to take a look at that because that's number one. We all want to act ethically and responsibly, but if you do get an ethics complaint against you, you may or may not have to engage counsel personally. I couldn't represent you in that, and it's just a negative mark against your reputation if something like that were to happen. So that's something I would be very mindful of. In terms of personal legal exposure, one of the realities of being on a board of education is at some point in time there's a good chance the board will be sued and possibly that you will be sued as a board member. Okay? It happens. And there are a number of protections for you. First and foremost is that there's a statute, it's 10-235, and it requires the school district to indemnify you if it gets sued, if you get sued. And that even covers if you make a mistake, okay? You engage in simple negligence, you're entitled to be indemnified. The only time you're not entitled to be indemnified is if you engage in wanton, reckless, and willful conduct. And, best way to describe that is you decide that, teacher Sam Smith is just gotta go. And you make it your life's mission and you do everything you can to get rid of Sam Smith. Your kids played football together, you didn't like the guy, whatever it happens to be. That is the kind of reckless intent. Now, that doesn't mean if you have a good faith belief that Sam Smith should go, you can't act appropriately. But if you're acting, willful, reckless, intentional behavior to hurt somebody, then the statute doesn't allow the school district to indemnify you. And also that holds true for defamation. You say that Floyd Dugas is a cheat and a liar in business, that's defaming me, right? And if I were, whether I'm a member of the public, an employee, whatever it happens to be, and if I turn around and sue you and it turns out it wasn't truthful, if I am a cheat and a liar, well then truth is always a defense. But if it turns out that it wasn't true and either you knew that or you recklessly accused me, then the law doesn't allow allow you to be indemnified. So, as long as you're acting in good faith, you're good. So just be aware of those concerns. The other thing, of course, is insurance. There is ample insurance, covers most things, not everything, but that's another layer of protection. And then lastly, not to get too technical with this stuff, there's something, if you engage in what's known as ultra vires acts, that means acts beyond your role. So let me give you an example of a situation that happened with one school board that I represent. Somebody, they had family in the roofing business, and they needed a new roof, and so they basically, you know, had some drinks or whatever with the contractor was looking for, and some promises were made. I'll get this, you know, contract for you. Well, as you'll hear in a second, when you're not sitting as a full board voting, you really have no authority. That was outside of your authority and responsibility, and there was a lawsuit there and ended up settling. But you know, that's the kind of thing where there could be potential exposure as well. When I mentioned that your authority is only when you're sitting here in a duly called meeting. Once you leave here, you have no greater authority than anybody else in town. And that applies to the ability to walk into a school and say, you know, I mean, obviously you get, as a board member, you will get certain courtesies the public may not get when it comes to, you know, you want to tour the schools or things of that nature. But otherwise, you don't have any duty or responsibility. The board chair has certain duties and responsibilities, setting the agenda, signing contracts and things of that nature. But other than that, you don't. So by way of an example, let's say you wanted some information, a whole bunch of information, documents, and you make a request. If the board hasn't requested those, just you have, you're treated no differently under the Freedom of Information Act than somebody in town who's not on the board. So just be aware of that. I have in here, only because it's come up a couple of times, is on top of page 4, participation in PTOs. I can't tell you it's prohibited. I can tell you that CABE and others think it is a bad practice. Part of the reason is that you're supposed to be, when you're on the board, concerned about all the children of Stratford, not just a particular school, and so for that reason, it's generally discouraged. Okay?
A quick question on that?
Yep.
When you say discouraged, the PTOs meet on a fairly regular basis, PTAs, PTOs. Are we discouraged from going
No.
to?
No, I'm saying, you know, you just don't want to get involved in running it and, you know, yeah, I would say don't be an elected officer, but if you want to go and listen, hear feedback, what the concerns are, that's certainly, I think, reasonable.
Don't be a member, don't be a, I don't know if they have, you know, membership, appointed membership, or,
Right, yeah.
okay, thank you.
Okay, so now I'm going to talk about the board function and then the role of the superintendent. I'm going to spend a fair amount of time here because I think this is an important distinction to draw. And again, whether you go to CABE, whether you go to the National School Board meetings, they really drill down on the separation of the roles. I've been doing this for 37 years. I can tell you when the roles are kept separate and everybody follows the chain of command and honors that, things operate smoothest. So, and again, most of this comes from statute, but you know, also a lot of it is sort of interpretation of statutes over the years. So I mentioned early on the primary role of the board is to promulgate policy. So there are different components of that, of course. You help to establish a vision for the Stratford Public Schools. You help to set goals that'll achieve that vision, raise scores, you know, diversity, whatever it happens to be. Then you formulate policies that help to accomplish those goals. You evaluate the results relative to the goals, and then you amend the policies as appropriate. And importantly, it is the administration that is responsible, superintendent, his or her staff, for implementing the policies. That is not your responsibility. You got enough to do at these nightly meetings. That's their responsibility. I will tell you, you have a lot of policies that are from 2015. The world has changed a lot from 2000, certainly in education, and I certainly encourage a real hard look at your policies to try to bring them up to date.
That is part of our current process.
Okay. As I said before, a lot of what through the adoption of your budget, you're doing a big chunk of what you're supposed to do. Another important role is to hire and evaluate the superintendent of schools. And by the way, what we say is that you have one employee, that is the superintendent, and everybody else below the role of superintendent is the responsibility of the superintendent. They're not your employee. You just manage and deal with the superintendent. If you are not satisfied with the superintendent, there are a number of remedies, obviously, but that is your one employee and the one person you have to be concerned about. You also, I talked about the policies, but there are some other very specific responsibilities you have under the law, and one is to bargain collectively with your unions. Now, typically, that has been done. It's changed a little bit over the years, but generally speaking, that is delegated to a combination of the business manager, to the human resource director, to me as board attorney. Typically, for example, with the teachers, I've always done those because that has such a significant impact. I have most of the time been involved in the non-certified, but not always. But that's only because we're doing what's your job and your responsibility. So the way that it works is we will negotiate the contract, and then we will bring it back to you for approval. And there will also typically be members of the board sitting in on negotiations, certainly if it's teachers, probably if it's administrators, and often if it's some of the other groups, depending on availability. And that sitting in on the negotiation is how you're kept apprised. We for example, when we start teacher negotiations, I'll meet with you guys and say, what do you see as the important issues, and get that feedback incorporated into the process, and then come back and report to you what's going on with negotiations, because ultimately it's going to come back to you and you've got to vote and approve it. Things like student expulsions, school accommodation hearings, under the law you can either hear those yourself or delegate them to a hearing officer. We've typically delegated to a hearing officer, which personally I think is really good practice because, number one, this job, quote unquote, takes a lot of your time as it is. And those proceedings can get pretty technical from a legal standpoint. So typically a hearing officer is an attorney who's done plenty of these and they're experienced, and it's good to have that input.
I think we had passed, didn't we?
We have a third party.
We have a third, who is, I don't know if Heather knows or Floyd, if you know. Do we have a third party who we use regularly?
We do, yeah.
Hmm? Okay, so we have okay, thank you.
Okay, another thing that you may be asked to get involved in is our grievance hearings. Some of the collective bargaining agreements, not all as I recall, have you as a step in the grievance process. And if and when that happens, I'll give you a little bit more guidance and direction, but basically there are two types of grievances. One is discipline, and if discipline has been issued and the employee grieves it and it comes to you, the question you have to decide is whether the administration had just cause to issue the discipline. If you think they did, then you deny the grievance. If you don't think they did, then you sustain the grievance and you can adjust it accordingly. The other type of grievance is what I'll call a language grievance, and that's somebody claiming the administration has violated the labor contract in some fashion. Somebody who should have got promoted didn't get promoted. Somebody didn't get the right overtime. Things of that nature. In that case, what you'll be asked to determine is whether the contract was violated. And sometimes that's as simple as looking at the language, but often it's not quite that simple. The language isn't always crystal clear, and past practice comes into play, and that's something we'll have to look at, but understand you may be involved in that. Where it involves discipline, I'm going to talk about this a little bit more when I talk about teacher terminations in a second, but typically you will not get a lot of information prior to the hearing. And the reason for that is when discipline comes, particularly if it's fairly serious discipline, which I would classify as more than 5 days. When it comes to you, the law views you as essentially a judge and a jury. And like any judge and jury, the law guarantees that the individual has a right to due process, and that means somebody who hasn't already made up their mind about it. And so if you get a whole lot of information, someone could argue, how could they have not made up their mind about this? And that's why you'll see that typically boards will not get a whole lot of data before you have to sit and decide those. That's especially true in teacher terminations. So let me talk a little bit about that. There is a state law, the Teacher Tenure Act, and I don't think it's an overstatement to say it is one of the teachers have, and by teachers, I'm talking about everybody below the rank of superintendent. Assistant, principals, teachers, and what the law says, again, is that they're entitled, they have tremendous protection under the law, specifically what we call substantive and procedural due process. Procedural due process is you follow a process, you give them an opportunity to have their say, and substantive due process is you have to have a good reason as opposed to an arbitrary and capricious one. So let's say someday you find out that a teacher, or under this example, a teacher was arrested for selling drugs. Okay, you can't just say, and they've found the drugs on him red-handed. You can't just say, sorry, Mr. Teacher, your employment's terminated. We have to follow due process, so understand that when something may seem very obvious, we have to follow the process. Otherwise, somebody has various legal claims that they can make, and so, and that applies to a teacher termination. They're pretty rare because usually we will work it out ahead of time. Usually it's the administration will convince the teacher that, you know what, this isn't working out, time for you to move on. And these days, with the disclosures that have to happen and Google and everything else, it's best if a situation is such that the teacher probably needs to go, it's best that they sort of agree and we work out an arrangement and they go away without it having to come before you. But if they choose to fight it, eventually what happens is they have a right to either have a hearing before the Board of Ed or an independent hearing officer. 95% of the time, they're going to want an independent hearing officer. If that happens, we will go through hearings, and then the hearing officer will make findings of fact and a recommendation. And then that comes to you. You have to accept the findings of fact, but you don't have to accept the recommendation. Hearing officer says, okay, that was bad, but give them a 15-day suspension instead. And you say, not in our district. We're not going to allow that. We want to fire you. You can do that. But again, it's important that before that happens, somebody doesn't quote you in the grocery store or at the sidelines of a football game or God forbid, in the paper saying, oh, I just heard about that teacher being arrested, that Dugas has got to go. Because now you have predetermined the issue, and if you don't recuse yourself, you give somebody a great basis for overturning their termination, probably after 3 or 4 months, if not 6 months of hearings, while under the law you must continue to pay them, and legal fees, including the arbitrators and transcripts, can get very, very expensive. So just understand, if we are in that mode, you won't get a whole lot of information up front, and there's a good reason for that. Committees, I know you guys have committees. I think this is spelled out pretty good in your bylaws, but committees have no authority. All they do is make recommendations, and then the full board has to vote on it. Committees also have to follow the Freedom of Information Act. Okay? Post notice, keep minutes, have open meetings, and so on and so forth. Chain of command is an important concept in schools. Generally speaking, the complaint should be referred to the lowest level of the problem. Somebody's having a problem with the teacher, you refer them back to the teacher. They're still having problems, you refer them to the principal. If the principal's a problem, or they're getting nowhere with the principal after talking to the principal, eventually you refer them to the superintendent. You should not yourself get directly involved for the reasons I was talking about before, but just refer them to the appropriate, the lowest level in the chain of command to get it resolved. Confidentiality is a very important part of all this and what you do. Basically, two areas. One is students. There's a federal law, the Federal Education Right to Privacy Act, also known as FERPA, you may hear about. Under FERPA, personally identifiable information about a student, grades, whether they're special education, that should not be disclosed to anybody who doesn't absolutely need to know. It is incredibly rare that a Board of Education member needs to know. Usually that's the administration that deals with it. Now, if you were asked to, so in any event, sometimes what will happen is, a parent will get up and my child's a, special education student and they're not doing what they need to be doing for my child. The parent's self-disclosing, that's obviously not an issue, but not a good idea to get into a back and forth or to discuss it afterwards. Or the way this sometimes comes up is a parent says, my kid's in school with, little Johnny Jones. I know that kid is, ADHD or whatever he happens to be, and he's a real problem. You then communicate that to somebody else. That's a potential FERPA violation. So just need to stay away from talking about students. The same is generally true when it comes to personnel matters, not because there's a statute like FERPA protecting employees, but for the reasons that I talked about before, about if it comes before you, for example, a disciplinary situation, you need not to have prejudged it, but also, we run the risk that the union would get involved and file a grievance or an unfair labor practice if we've said something derogatory. And of course, there's always the possibility in this day and age of slander and libel suits. So best, again, to leave personnel matters to the administration. Okay. Let me shift gears now. I've sort of told you what your role is in terms of the policy. I want to talk about the superintendent's role to kind of draw a distinction. Under yet another statute, 10-157, the responsibility for the day-to-day operation of the schools is the superintendent's. It's not the board's. The statute goes as far as referring to the superintendent as the chief executive officer of the board, but clearly delegates the day-to-day responsibility. It also delegates supervision and evaluation of all staff. That's what I said before. The superintendent is your employee, your only employee, and everybody else is the responsibility of the superintendent. Superintendents don't have tenure. Everybody else, yeah.
Just a quick question about the day-to-day operation. Under, as far as things like contractual obligations of the board and things like that, is that considered day-to-day operation?
It depends. If we're talking about a contract that's covered within the current budget, then I would say, yeah, that would fall under their responsibility, but there may be.
If it's defined under the current budget, or?
Well, let's say that.
If it's a new contract in the middle of the year that wasn't discussed with budget.
Right, but if it can be paid for out of the existing budget, then that's okay. But some boards actually have a bylaw that require some level of approval, okay? Just for example, I happen to know Bridgeport has a policy, I think it's over $50,000, it has to be approved by the board. First goes to a subcommittee, so you can insert yourself in that process. If it's a multi-year, you absolutely should be involved, in approving it. Bus contract, again, a copier, 3-year lease, and we probably also have to have the town approve it as well.
Thank you.
Superintendents, unlike everybody else below them, do not have tenure. And that's why we give superintendents typically a 3-year contract. You cannot give a superintendent, as a matter of law, a contract for more than 3 years. But I don't think can't remember the last time I saw a contract that was less than 3 years for a superintendent, unless it was like a 1-year extension for somebody who there were some concerns about or something of that nature. But the reason that we typically do that is because they don't have the protection everybody else has, right? And of course, as you guys, I'm sure know, you have to evaluate the superintendent annually. Superintendent's involved in that process. I touched briefly on termination of teachers. The superintendent initiates that process. The superintendent also, that's for tenured, but also for non-tenured folks. We refer to that as a non-renewal. The burdens, until somebody is tenure, it's a lot easier to simply terminate them at the end of the year. We call it a non-renewal. You send them a letter by May 1st. If they're not tenured, then they're done. They also have responsibility for any termination of non-certified employees, secretaries, paralegals, custodians, and folks of that nature. Now, on pages 6, 7, 8, I have a chart here that on the one side, talks about what the board's responsibility is, and on the other side, what the superintendent's responsibilities are. I won't go through all of that this time. I'll point out a couple just to show you some examples, but for example, the second bullet point, the board's responsibility is to establish and regularly review all policies, ensuring they are lawful, designed to improve the quality of the school district. The other side, which is the superintendent's responsibilities, are to implement policies approved by the board and to recommend changes if appropriate, and to implement and inform the board of necessary changes. On page number 7, responsibility of the board, second bullet point, to refer communications such as questions, complaints, and personnel inquiries to the superintendent as appropriate, and encourage the adherence to the established chain of command. I touched on that. On the other side, superintendent of schools has an obligation to respond to that and address it and keep the board members informed about any issues that come up in a timely manner. Again, this is only going to be just very basic general information, particularly when it comes to students and staff. So again, I'm not going to go through all of those, but you might want to take a look. It'll give you a good sense of what the respective responsibilities of the board and the superintendent are.
Just before we move on?
Yep.
So, initiates teachers' terminations, back on item 6. You had said teachers is everybody below the superintendent. Is that included in that language as well?
I'm sorry, what's the?
So back to before F, the last item.
Oh,
page
number 6, yep.
Yeah. Teacher, it initiates teachers' terminations. Is that everybody below based on that language?
Yes.
So then how do we as a board, say we've got a superintendent who's a bully, doesn't, for whatever reason, doesn't like a member of his staff, or how do we as a board protect a teacher or staff member who's being bullied, say, by a superintendent? Not that I'm saying it's happening, but just.
Yeah, I mean, how do you protect them? On one hand, I think some would say that's not really your role.
Mhm.
On the other hand, if it's happening, your role is to address your employee,
Mhm.
superintendent. And you can do that, in any number of ways, including, whether to renew the contract, in the evaluation process, in theory, even move for a termination under their contract.
Is the employee's only remedy, would the employee's only remedy be a grievance, or?
Well, if they're in a union, yes.
Yeah.
So for everybody who's in a union, in those situations, sure, they file a grievance. Courtney will tell you they file them all the time. And that's one way it could get remedied and addressed.
Okay.
They could also file, in some cases, what's known as an unfair labor practice, get it addressed in some fashion. The folks who are not in a union, assistant, director, special ed, business manager, those folks don't have that, the union protection, so they'd have to think about some other vehicle for pursuing, addressing it, but again, you really don't, under the law, have a role there, other than holding your superintendent accountable.
And we had talked about this a little bit, the board's authority over hiring and I think firing as well. Do all those, say it came to a termination, would the board have the ability to say no to a termination because it was aware of information, bullying, whatever it might be? And
If it were a teacher termination, for example,
Yeah.
or an administrator,
Mhm.
again, I'm talking, then the way the process, forget the union for a moment, because they could grieve it, it could come to you,
Mhm.
and in those situations, if they're in a union, then you could say, yeah, we agree with the union and the teacher, that it was too harsh,
Mhm.
and it shouldn't have been. So that's one way to fix that situation. For the folks who aren't in unions, not a whole lot of recourse that they would have through you in those situations. Okay, just a couple words about the role of the board attorney. You represent the board, meaning all of you. We also, obviously represent the Stratford Public Schools, working with the administration. We don't represent folks individually. Now, that's not to say if there were a lawsuit and you were named that we wouldn't defend everybody, including the Stratford Public Schools and the Stratford Board of Education. But for example, like I mentioned, if there were an ethics complaint against you or defamation claim, we could not represent you. We provide advice. We like to think most of the time it's good advice and that folks follow what we say, but I'm aware that at the end of the day, that's your decision. You may know the town much better than I do and what's right and wrong. So, I would never tell you that, have a temper tantrum because you didn't follow the advice. I'll give you my advice and you follow it. We are a law firm of almost 40 lawyers. There are other folks that get involved. On the special education side, for example, you'll see Michelle Laubin for my office. I've got 7 people who work for me, who also assist me in doing what I'm doing. So you may hear some of that. Okay. I've already touched on the collective bargaining, so I'm going to jump down to the Freedom of Information Act. We could take probably 2 hours talking about the Freedom of Information Act, right? But basically, there's 2 parts of it. The first deals with public records, and the others deal with meetings, okay? And as a general rule, every piece of paper, every electronic piece of information, every email, every text message you may send each other or a member of the community that deals with Stratford Public Schools business, okay? It's an important distinction. If you're talking about the Super Bowl, obviously it doesn't apply. But if you're talking about school district business, that is a public record and it's subject to disclosure, okay? Now there are exceptions to that: student records, security plans, certain personnel information, teacher and administrator evaluations are exempt, okay? Not discipline, but the evaluations themselves. And there are some other exceptions, but that's basically the general rule. For the most part, you won't get involved. Generally, that's the superintendent's office in Port Teresa who has to deal with FOI requests and pulling them together, and she'll consult with us. So it's pretty rare that you would have to get involved in that. If you get an FOI request, just send it to the superintendent's office and it'll be addressed. But the reason I mention that is text messages, for example, or emails, either one. If somebody wants to FOI that, if it relates to school business and it doesn't fall into one of the limited exemptions, they're public records, okay? So be mindful of what you're doing, and if somebody were to make a request, and it happens, they could look at your email, your Stratford Public Schools email, and by the way, they can look at your personal emails if it has to do with school district business, okay? So be mindful of that. And you know, the old story about don't hit send until you count to 10 and say, "Would I want to read this in the Connecticut Post tomorrow?" You know, certainly because there've been some embarrassing things that have come up over the years of some emails that folks have sent, and the same applies to text messages in this day and age. If somebody were to make an information request, we'd have to, you know, you'd have to go down and download it, and it's not so much that they would necessarily be able to get your phone and look at it, although in theory the Freedom of Information Act might be able to have some access if somebody claimed there was a communication. They knew there was a communication, somebody told them about it, or they saw it on somebody's phone, you know, it could get to that level. And by the way, for that reason, what I always advise is any written communication should be through your Stratford Public Schools email account, because if something comes up, it's easy enough. I mean, then you just say to the superintendent, you know, you pull that information, right? And IT will work, and they'll pull it together, and you don't have to worry about searching your private emails and people, you know, looking at stuff that might be in there. Okay. The other, now that goes more to a public meeting. So that's just the general rules when it comes to public records. The other side of it is meetings. And some of this, you know, most of this you guys are certainly going to know, but there are 3 types of meetings. There's 4, I'll talk about that in a second. There is a regular meeting, there's a special meeting, and there are emergency meetings. Emergency meetings aren't because I want to get something out before the holiday. You know, it truly has to be an emergency, so that should be used only sparingly. Importantly, at a regular meeting, you can amend the agenda. You need a 2/3 vote to amend the agenda, to add the item, and then of course you vote on it by a simple majority. At a special meeting, you cannot add anything to the agenda. Okay. Then there's executive sessions. And executive sessions, the law recognizes that there are some things that are so important for you to be able to talk about in private, they make an exception. And there are a number of them, but the ones you typically will run into would be to discuss a personnel matter, to discuss a legal opinion, to discuss security plans, and there are some others. The important thing there is you can't say, well, we want to talk about something because we think it's an important issue, but we don't really want to do it in the view of the public, so let's just call it an executive session. Can't do that. If somebody were to find out, they'd file a complaint, and there could be some consequences by doing that. The other thing that's important about executive sessions is, the old saying about what happens in Vegas stays in Vegas. It applies to executive sessions as well. And it's for a lot of reasons, one of which, of course, is that you undermine the trust of your colleagues if things are disclosed and come out of there. But you've also, if you tell somebody what happened in executive session, you've now had an illegal meeting. Because only those folks who are in executive session, the information has to stay in the executive session. I'm sure you know this, but when you go in, you have to state the reasons, got to be a legal reason. Personnel, superintendent, personnel, teacher Floyd Dugas. You've got to list the name of the person. You can also go into executive session to talk about a lawsuit, but you've got to name the lawsuit, or if somebody's threatening to sue you, you have to identify who they are. But there's very limited reasons for executive session, and what happens there stays there. And in addition to announcing why you're going into executive session, if you're inviting anybody other than yourselves in, superintendent, myself, anybody, then you have to say who that person is. Okay, and you're really only supposed to have people in there who you think you may need information from. Okay, so if somebody just wants to participate, that doesn't fly.
Just a quick question, a regular meeting may add to agenda by a 2/3 vote. Is that Robert's rules, is that state statute?
That's state statute.
State statute, okay.
Okay. Now, you may hear the term non-meeting, okay? And what that means is that there are certain things that under the Freedom of Information Act, the law has said these don't constitute meetings under the Freedom of Information Act. So you don't have to comply with the act. You don't have to put out an agenda. You don't have to keep minutes. And there are only a few things, one of which is to discuss strategy for labor negotiations. So if we're going into negotiations and we want to talk, we don't need to put it in the agenda. We don't need to list it as an executive session item. We could do it just before a regular meeting. Just meet and talk. So that's one item. The other is a hiring committee. So typically what will happen for a fairly high-level position, for example, superintendent, you would appoint yourselves as the hiring committee. And if you do that, you can meet and discuss it, interview folks, and you don't have to comply with the Freedom of Information Act. Keep it all confidential. And then the last one is a political caucus of a single party. All the Democrats, all the Republicans, you can meet together. You cannot have anybody else, though, in that meeting. You can't have the town committee chair, you can't have the board attorney, you can't have the superintendent, you can't have the mayor. Okay? It would just be your political party. One thing that I would say that may not seem so obvious, though, is you can actually have an illegal meeting through email. Okay? And the classic example is somebody goes off on a rant or imparts some very important information, and then somebody responds and hits reply to all, and now you've got a quorum of you communicating about board business. That is an illegal meeting. Okay? And so be very mindful. That doesn't mean that, first of all, if it's just organizational, want to have Attorney Dugas come in 6 o'clock on the 22nd of January, is everybody available? No problem. That is not something, you know, even if you were communicating back and forth, that's okay, you don't have to worry about it. If it's not school district business, you know, there's going to be a holiday party and let's meet at, you know, so-and-so's, not school district business, you can do it, but if it's anything over which you have responsibility and jurisdiction, and it's more than a quorum of you communicating, then that would be an illegal meeting, so be very mindful of that.
And just the political caucus, so there's 3 Democrats on our committee, on our board. In essence, they could not have an illegal meeting. The 3 of them could meet with whoever they wanted.
Sure.
The 4 of us could not, the 4 Republicans.
Well, the 4 Republicans can meet.
Only if it's the 4 of us.
Yes.
But if it was the 3 of us, we would be, say it was only 3 of us, then we could talk with other Republicans or
Well,
without it being.
the 3, if there are 4 of you, 3 of you could meet. If somebody couldn't make it, that's fine.
Yep.
But what you can't do, again, is meet with somebody else.
Yes.
Town chair, mayor.
Doesn't matter whether.
But the 3 Democrats could meet because it doesn't
No.
constitute a quorum. They could meet with whoever they wanted
Absolutely.
because it doesn't
Yes,
constitute a
yeah, I
quorum.
mean, if it's less than a quorum, anybody can meet,
Yep, okay, gotcha.
okay? Once you hit number 4,
Mhm.
now you've got a quorum, and if you're talking about board business, then you can't do that.
Thank you.
Yep. Okay, only other thing I have here, and then I will see if there's any questions. I know we've got a board meeting coming up, is Robert's Rules. Unlike FOIA, Robert's Rules is actually not a law. It is a set of procedures, parliamentary procedures, which you agree through your bylaws to follow. Okay? Now that doesn't mean you shouldn't follow them. Of course you should follow them because they help you to run an orderly meeting by doing so. But just be aware of that. And again, Robert's Rules is something where we could probably do easily an hour presentation on. Brian LeClaire from our office, who's one of the assistant town attorneys, is as close to as an expert as I have on this. If you ever wanted, I could have Brian come in and give you a presentation on Robert's Rules. Okay. And I just go to the last page, on page 11. I mentioned the Town of Stratford Ethics Ordinance. If you just Google Town of Stratford Ethics Ordinance, it'll pop right up. I did it just before I came here. And as you can see, some of the things it addresses is you can't have a financial interest in any business that the board's engaged in. You can't deliberate, vote, or even participate in discussions on a matter in which you have a personal or financial interest. Where that typically comes up is if somebody has a spouse, for example, who's in a bargaining unit, you couldn't participate and vote on that. If it's pretty remote, it's your son or daughter and they don't live in your household, that's a little different. You know, that's generally not considered a problem. You can't engage in employment which is incompatible with your role as a board member. I'm hard pressed to think of as an example, but just be aware of that. You can't disclose confidential information, and you can't receive more general, more favorable treatment than the general public. If you had a rule about, you know, which school your kids have to go to, you couldn't get a special exception for yourself because you're on the board, basically. That would arguably be a violation of the ethics ordinances. And then in your bylaws, there are 3 things. It's a little bit of it's actually quite a bit of an overlap, but there's 9270, which is conflict of interest, 9271, which is your code of ethics, and then 9272, which is the code of conduct. Behind that, I've given just a little primer on what a grievance is and what your roles are. So if and when that comes up again, I'll be, you know, happy to sort of walk you through it. But that's, those are the highlights. Happy to answer any questions you may have. You probably need a little break before your meeting at this point, but happy to answer any questions.
You and I had talked a little bit about before the meeting. Can you talk a little about, would this be appropriate time for you to talk a little bit about the hiring authorities
Sure.
within the district, whether it's the board or the superintendent or who has those authorities?
So I provided you with a memo. Hopefully I can find it here. Yeah. So what the statutes do is they say that you may authorize the superintendent to be responsible for all hiring, okay? But because it says you may authorize, doesn't mean you have to, okay? Now, by the way, I'm talking simply right now just about certified staff, teachers and administrators, okay? So the statute says you may, but you don't have to. I've seen it all over the place in Connecticut. I would say most districts probably leave it to the superintendent. Maybe a third do that. A third have it almost as a pro forma where it'll be on the agenda for approval. Nobody ever raises an issue, objects, but it's on there. And others will have a much more hands-on role. You may separate it between teachers and administrators, okay? You may want to have more of a role. The role can be, you know, committee. The role can be the ability to reject a recommendation. So all of those things are fair game. The only thing I'll say, which I said in the memo, and I'm sure Courtney, you know, could appreciate this, and I would encourage you to talk to her. I can't tell you how many school districts, you know, I've been in a meeting and the personnel director is sitting there, or I'm sitting there with the superintendent. Personnel director comes in and says, I finally found that physics teacher, or that math teacher, that Spanish teacher. I need to make her an offer right now. We're going to lose her, and you know, but I got to go to step 6 to make it happen. The superintendent says, "Fine, hire her." And I've had, you know, seen situations where people have lost because they weren't able to respond quickly enough. So, in whatever you do, you can be responsible for all, have a role in all certified hiring. But I would encourage a conversation so that you have a good sense of what makes sense, you know, in this day and age. I mean, again, I would say it's most school districts would give the superintendent and the director of personnel the latitude to hire teachers, and reserve it for more, you know, higher level positions, principals, assistant principals, and things of that nature. But you can do whatever you want. Most school districts, the board does not get involved in non-certified hiring, secretaries, custodians, paras, but in theory you could. There's nothing stopping you. So, and there's no real right or wrong, one size fits all. Every community has their own sort of philosophy and approach. You know, we can certainly look at what other districts have done and figure out what makes sense for you guys.
So when you had said, you know, we find that physics teacher we've been looking for the last 5 years and offers made, they don't start in the morning. There's a process they need to go through.
Sometimes it's Monday.
Yeah, is it? Yeah. Okay.
Sure can. If they're available and they're not being held to like another contract by another school district, because sometimes school districts can say, we're going to hold you to 30 days, but if they're not being held to anything, you can immediately.
But you think I would think you'd want to have a certain review process with any hires. Most corporations, you know.
That's what he's saying. He's
Yeah.
saying
Well,
the difference between the teacher.
Yeah, to use that analogy, in a corporation, the board of directors isn't hiring the custodian and the ditch digger and the guy on the production floor.
They're hiring.
They're going to hire the senior vice president or director of labor, whatever it happens to be. It just can be, you know, again, under the law. I mean, I don't care. Do what you want, but you, just in my experience, and I would encourage you to talk to to Courtney and the superintendent about this, they need to have the flexibility to be able to move quickly to get folks.
Yeah.
I mean, imagine this. It's August 28th. You've got 16 positions you have to fill still. Do you really want to wait to the September meeting?
Right.
Well, the other side of it is, imagine we hire that person, don't do a thorough background check, and I mean, we also have to do a background check, which I would imagine takes some time.
And again, that's what you pay your superintendent and personnel director to do, and
Whether it be workers' comp, background check, whatever maybe. This person moves in from out of state. Oh, let's hire them. They sound great. They're awesome. And, 2 weeks later, like, uh-oh.
well,
What are we gonna get ourselves
and the way to deal with that, and I think we do this here, but you do a conditional offer subject to the background check.
Yeah.
And then when you get that thing saying, this person was busted 7 years ago for dealing drugs or, whatever it is that comes up, you can say, sorry, got to cut you loose because you didn't pass a background test.
So there could be that conditional offer.
Oh, absolutely.
Yeah. Okay.
Yeah.
Okay. Yeah. So,
I don't want to put Courtney on the spot, but I'm pretty sure we do that, right?
Yeah.
yeah. Okay, thanks. Does anybody have any questions or? And if you could email out to the entire board, and maybe to Teresa, that your opinion on the
Oh,
hiring.
absolutely,
Yeah.
sure.
I know you and I had discussed it, but just so we can share it with the entire board.
Will do.
So before we adjourn, on the attorney's report, one of the things I had asked Mr. Dugas to do was talk a little bit about the hiring, just for his time, so he doesn't have to sit around. We'll count this as his attorney's report, unless you have anything further during the meeting you'd like to report to us.
No, not at this time.
You don't want to stay?
All
All right. So is there any questions, concerns, so then I'll take a motion to adjourn.
So moved.
Second.
Moved by Mr. Dell, seconded by Mr. O'Brien. All in favor?
Aye.
Opposed? Motion passed unanimously. We'll adjourn at 7:15. We'll take a 5-minute recess and then start our meeting.
Thank you. Well, nobody fell asleep, so that's a good sign.